Thank you so much, Kathy, and it's a pleasure to be with you. 21st of February here in New York City. It's a little overcast, but feels somewhat like winter. I understand down in DC it's going to be 80 later this week, so who knows these days. We will be walking through a program, though, that I think you'll all enjoy, one that involves a number of our offices. So you'll get a flavor for really all that Bond has to offer as a multi-services firm. And so with that, let me walk through the agenda, Kathy, on the next slide. What you'll have at the top is me just going through a few updates, chiefly relating to what we know about the budget. Jeanette Lombardi is with us from Naples, Florida, where they know 80-degree weather very well. And we're glad to have a member of our Florida team with us. And she'll be addressing estate and gift tax matters. Later, we'll turn to Syracuse and Colin Carr, an associate who will talk about venue matters, which is certainly really interesting for those of you contemplating litigation. Staying in the litigation space, we'll move to Eric O'Brien with us from Albany, an associate there. He'll be talking about attorney fee shifting. And then we'll close out with Jackson Soames out of our Rochester office, who will bring light to a gubernatorial veto that is worth all of your time and consideration. And with that, Kathy, I'll walk through my material, and I look forward to sharing this forum with the others I've just mentioned. So to begin, in terms of the healthcare budget, we know things are still moving in Albany, and I'm focused on what we have in New York State, for this conversation. Some of the big ticket items, as it were, that in the healthcare space, those like I who spend time there are keeping careful tabs on is what to make of the about $1 billion in funding that's intended for transformation activities, chiefly in the capital space. There was just a round of funding in terms of final dispensations of applications announced for the third round of this same funding stream. So it's really important in the healthcare space, and we'll be working with clients on that, I'm confident, as the year progresses. Human services, there's a sense that there's just not enough money in the budget right now. So that's a place where we expect to see some activity. The cost of living increase of 2.5% is a whole lot less than the 8.5% requested, for instance, by the Human Services Council. And although this isn't a budget item, it's just worth your attention. The 1115 Medicaid waiver amendment. It's something that I've presented on before all of you previously. It would essentially be billions of dollars flowing through New York State if CMS ultimately approves what New York State has proposed. And this would be a continuation of the healthcare reinvention activities that the Delivery System Reform Incentive Payment Program funding began. Those monies, of course, termed generally at the end of March of 2020. And so this would be the next iteration, slightly reconfigured. We're still watching for when this funding ultimately is approved. It's a little bit later at this point than was at least thought to be the case in late 22. Some of this we expect has to do with changing priorities both within the administration and as well with plenty of other issues that the administration is focused on simultaneous to this. But as we get more information, we're going to keep all of you apprised. Next slide, please. Other things that we're watching in the budget, we've brought this forward to you before. For those of you who are involved with or otherwise pay attention to managed long-term care, which is a form of insurance that deals, or rather is oriented toward individuals living with pretty significant care needs. The idea is that New York State will re-RFP, put out a new request for proposal, essentially for this entire portfolio, which hasn't been done in years. It was something that was previously echoing last year, but ultimately was defeated by those who had concerns about it. We shall see whether it makes it into the final budget, but it'll certainly be contentious. There's some quality pool monies that are planned to go away if the budget is as the governor has currently proposed it. Of course, the Senate and the Assembly will have their own take on the same. Another big item would be transfer of the oversight authority for healthcare licensures, those that run through the state education department moving key licenses over to DOH, the Department of Health. That would be a huge deal if it were to happen. And again, this has been previously proposed and hasn't gone through. And then interstate licensure compacts are something that is on the table. There has been for a long time a sense that New York State would stay away from these kinds of agreements because of the sense within the state of the unique ways in which we practice, but the pandemic has changed a lot of those assumptions, and so we'll see whether that makes it to the final rounds and ultimately the approved budget. More to be discussed there. And then two more quick ticket items. First, on healthcare workforce investments. A lot of money proposed there for obvious reasons, given the nature of short staffing and other obvious need within the healthcare sector. And we'll be watching this other proposal, which would essentially add new processes of approval to transactions involving investor-owned entities, including physicians' practices. For the moment, those are not part of the more formal oversight of the Department of Health. And essentially, if the budget goes forward as currently constructed, that would change too. Next slide, please. And then just one other matter to keep one's eyes on. During previous updates on what's happening in New York State, I've shared with you plenty around how in health, rather in home health, there's been a drive to increase salaries. There were minimum wage increases both last year and $1 more that is scheduled for this coming year. As the governor has proposed in this current budget cycle, again, if approved, to essentially move minimum wage toward an inflation match with essentially a indexing. That is something that those in the home health space are very concerned about, from the advocacy perspective, because the whole idea that they posited was that by distinguishing home health and paying more for it, we were going to, as a state, increase competition in the field and get better candidates ultimately to take on this work. And there's worry that's been voiced about whether moving home health only slightly and then moving up minimum wage will somehow dilute that. So this is also going to be hotly contested. I think I've said enough, though, knowing that we have several speakers ahead of me. So with that, Kathy, let me turn to a quick introduction of Jeanette Lombardi, who, as I mentioned, is with us from Naples, Florida. We're delighted to have a member of the Naples team on the program. To my knowledge, this is the first, and we hope very much not the last. And what Jeanette is here to speak about is increased exemptions in estate and gift taxes for this calendar year 2023. We thought it would be great for you to have a chance to meet Jeanette and otherwise to get to know the estate types of matters that as a firm we cover a little bit more in depth. So Jeanette, it is yours to carry from this point forward, and we're really glad you're with us. Thank you.
Well, thank you, Gabe. Good afternoon, everyone. I'm going to be giving an overview on the increased exemption for estate, gift, and actually the generation skipping transfer tax also. So these are transfer taxes at the rate of 40%. The gift tax is a tax that is levied on a transfer that exceeds your exemption amount at the rate of 40%. The estate tax is a similar tax, but it is levied at death at 40% based on today's tax laws, and that is for any amount that you transfer at death that exceeds your exemption amount available at death. So this works in concert with the gift tax. If you gift during your lifetime and use up some of your exemption, you have less exemption available at death in order to transfer wealth without the tax. In addition to that, there is a generation skipping transfer tax that could apply. That tax is also 40%. Now, the exemption amount now is mirror to the estate and the gift tax. That has not always been the case. And what happens is if you gift directly to what's called a skip person, which is either a grandchild or more remote descendant, or perhaps an individual that is not related to you by blood, but they are 37 and a half years younger than you are, that's considered a skip person, a direct skip, and you might be subject to a 40% tax unless you allocate your GST exemption. So the increase this year is that everyone has 12.92 million available to either transfer now using a gift tax exemption, perhaps even allocate GST exemption to that transfer if it's going to perhaps a dynasty type trust. A dynasty trust is one that allows you to make a transfer that will cascade down various generations without a further transfer tax. In Florida, which is where I'm located, we have a 1,000-year rule against perpetuities, which means that an irrevocable trust from the date that it is created and funded can exist for 1,000 years, which will cover many generations. So with this new increased exemption, which increased 860,000 from 2022, you have a very good opportunity to do some wealth transfer planning. A couple can actually protect $25.84 million with these exemptions, and you can do this in a variety of ways. In addition to the increased exemption of 12.92 per individual for gift, estate, and GST taxes, we have an increased annual exclusion amount in 2023. That was effective also January 1st, 2023. Now you can gift $17,000 per donee annually without any gift tax consequence. So if you have a lot of really good friends and you want to gift $17,000 to 100 individuals, you can go ahead and do that, and there is no gift tax consequence. If you are married, you and your spouse can jointly gift $34,000 to any individuals that you want. Annual exclusion gifts can also be used to fund certain types of irrevocable trusts, such as trusts that own life insurance policies. So that is another good way to make sure that you start to transfer assets out of your potentially taxable estate to other individuals, family members, friends, and the like. So gifting now, I'm a trust and estates attorney, so I like gifting, and I do ask my clients who have a gross taxable estate that exceeds the exemption amount to consider gifting often. So this is a prime example that if you go ahead and you gift this year that additional $860,000, you're going to basically protect that amount and all the appreciation on that amount outside of your gross taxable estate, minimizing any taxation at death. There are also some additional simple strategies that you can use to reduce your potentially taxable estate without any type of gift tax consequence during your lifetime. These are only available during lifetime. One of those is that you can make tuition payments directly to an educational institution for the benefit of anyone. The key here is that you must pay the educational institution directly. This could be for elementary school, college, graduate school, technical school. You can also make payments of uncovered medical care expenses for a loved one if they have recurring medical expenses that they are unable to pay for. You're benefiting your loved one, and there is no gift tax consequence to that. And last but not least, you're also able to go ahead and pay for health insurance premiums. So if you have someone in your family that cannot afford health insurance, you can make those health insurance premium payments directly to the health insurance company, and there is no gift tax consequence to you, and there is no gift tax or income tax consequence to the recipient or the beneficiary of that gift. In sum, this is a good year for you to consider if you have a taxable estate or a potentially taxable estate, to work with your trusted professionals in a team approach and make sure that you maximize the wealth preservation strategies that are out there and minimize taxation to your estate. Thank you, Gabe.
And let me say thank you, Jeanette, for taking the time to be with us. Really hopeful that you'll come back, and please invite your colleagues from Naples to be part of future programs. And with that, let me turn to our next speaker, who will be Colin Carr. Colin is joining us from Syracuse, where, of course, we've had speakers in the past. But Colin is also new to the program. And Colin is an associate, as I mentioned, with the firm, who focuses on litigation and who is going to be addressing new venue concerns for corporations in New York State. Colin, we're delighted to welcome you, and we look forward to learning. Thank you so much for taking this time.
Thank you, Gabe. I appreciate it. I'm happy to be here. Okay, so Kathy, can you pass on to the next slide, please? Okay, so recently the First Department issued a decision that has fairly significant implications for where venue is proper for corporations in New York State. So the initial question is, what is venue? And the term venue in New York State civil procedure means the county in which a lawsuit is maintained, essentially. And although it might appear insignificant on its face, where a venue is can have significant consequences for the success of your litigation. For instance, where a lawsuit is filed can create powerful imbalances in the financial burden of litigation between two opposing parties. For instance, a plaintiff whose attorney is located directly across the street from the courthouse in Westchester County, and if the action is commenced in Westchester County, will necessarily pay a lot less in legal expenses than the defendant whose attorneys are located, say, in Buffalo. Also, where excuse me. Also, where a lawsuit is filed can also provide a competitive edge at various stages of litigation. For instance, a mindful attorney might choose a venue in which that attorney regularly practices because that attorney will be familiar with the individual justices in that venue, as well as the individual preferences and temperament of those judges. Okay, next slide, please. So where is venue proper? Well, that question is governed by the New York State civil procedure law. And typically a lawsuit may be commenced in the county, 1, where one of the parties resides, 2, where a substantial part of the events or omissions giving rise to the lawsuit occurred, or 3, if none of the parties reside in New York State, wherever the plaintiff designates venue. And for purposes of this topic today, a corporation resides in the county where its principal office is located. Next slide, please. Which brings us to the case of Marte versus Lampert, which is that decision from the First Department that I referenced at the start. In this case, a lawsuit was commenced in Supreme Court, New York County. The corporate defendant sought to transfer venue to Supreme Court, Nassau County. And Supreme Court, New York County, granted that motion. Next slide, please. But the First Department reversed and said that the proper venue was actually in New York County. And the reasoning that the First Department relied on was the fact that the corporate defendant's certificate of incorporation listed New York County as the county in which the corporate defendant had its principal office. As such, the corporate defendant was a resident of New York County, and the lawsuit needed to be maintained in that county. Next slide, please. The unusual twist to the case, however, is the fact that the corporate defendant had no presence at all in New York County. The only reason that venue was proper is because of what was stated in the certificate of incorporation, which, although it wasn't explained, probably was outdated. At one point, the corporate defendant probably did have a corporate office or some kind of presence in New York County. However, at the time this lawsuit was commenced, it didn't have any presence in New York County at all. Just the certificate of incorporation said that's where its principal office was located. In fact, its actual location where it had its office was in Nassau County, which is the county to which the corporate defendant had requested transfer for venue. And the First Department said, quote, "The corporate residence designated in the initial certificate of incorporation controls for venue purposes," unquote. Next slide, please. So what are the implications of this case? Well, following COVID-19, there's been a lot of movement for corporations. There's been a cultural switch in preference to remote work. And also corporations, given this cultural switch, don't want to pay for leasing office space in urban areas where such rent can be quite costly. And so a corporation who had its principal office in some city, whether it be New York City or otherwise, in 2023 might not have any presence in New York City any longer. However, its certificate of incorporation might still state that New York County is where it does have its principal office, as was the case in Marte. And this is significant because if you no longer have a presence in a certain county or venue, then you could find yourself hailed into court in some faraway county due to an outdated certificate of incorporation. So with this decision in mind, corporations should be mindful and regularly try to review their certificates of incorporation to make sure that nothing in it is outdated. And if there is something outdated in it, such as where the principal office is designated, to execute an amended certificate of incorporation so that this issue can be fixed. Such diligence could determine the success of future litigation, and it should not be taken lightly. Next slide, please. And that's it for me.
Well, Colin, that was really interesting. And what I think is important, as you pointed out at the close of your presentation, is take a close look at those papers, especially to the degree with COVID, things have shifted around in ways that are profound. So we're here to help if you need guidance as you go back and need to make updates. And Colin, thank you for raising this to everyone's attention. Really appreciate it. And with that, let me turn to Eric O'Brien, who is with us from Albany. Eric is also new to the program and like our previous presenter is a litigator. And what I can tell you is that we're going to hear from Eric about some really interesting material that we thought was also worth your time. And so with that, Eric, I want to give you the floor. I'm really excited to be learning along with you. And the floor is yours. So thank you.
Thank you so much, Gabe. It's a pleasure to be here today. I have the pleasure of discussing what is a favorite amongst many clients, and that is attorney's fees. As anyone who has retained any legal counsel is aware, good legal representation is very necessary, but it can also be expensive. Unfortunately, for those who have been involved in litigation, these fees can increase significantly. The cause for this is both the lengthy nature of many litigation tasks and also the lengthy nature of litigation overall. Parties are legally required to undergo many of these litigation tasks, including the preparation of pleadings, the production of documents, preparation of paper discovery, depositions, and the attendance at many court conferences. These fees are further compounded by the decision to prepare and file motions within a matter. Accordingly, many clients seek to explore any and all possible options to reduce the likelihood of litigation. One of the best tools for this goal is the preparation of a carefully constructed contract. In doing so, clients will regularly inquire whether or not attorney's fees may be shifted from one party to another. Clients who may be bringing a lawsuit or when they are on the receiving end of a pre-litigation demand or a lawsuit will often make this inquiry and see whether the fees for their legal representation can be recovered from the opposing party. While attorney's fees can be recovered in some cases, many times the fees for your legal expenses are not recoverable. The shifting of attorney's fees from one party to another typically occurs under two circumstances. First, where the litigation is based upon a contract that contains a provision that permits the prevailing party to recover their fees. As I mentioned, many well-constructed contracts for a variety of services and goods can contain this type of provision. The inclusion of this type of term is a common option to protect clients from costly litigation, as this attorney's fees provision can many times motivate parties to explore early settlement prior to significant attorney time has been dedicated to the file. And thus, there are much lower incurred fees at that time of discussion. The second time where fee shifting may occur is where the relevant law that is at issue in the litigation provides a right to recover the attorney's fees expended. This is particularly important for clients who are employers. Most of the relevant employment statutes provide for the shifting of attorney's fees. These include, but are not limited to, employment discrimination and retaliation statutes, including the New York State Human Rights Law, the New York City Human Rights Law, Title VII of the Civil Rights Act, the Americans with Disabilities Act, the Equal Pay Act, which prohibits discrimination on the basis of gender in the payment of wages, and the Rehabilitation Act, which prohibits discrimination against individuals with disabilities in the federal sector. Similarly, Fair Labor Standards Act, which provides certain standards for employment, which most of us are familiar with, including establishment of a minimum wage, overtime pay, record keeping, and youth employment. And its New York State counterpart, the New York Labor Law, will also provide for fee shifting, in addition to some other available statutes which may provide for fee shifting. Matters brought under the last two statutes, the FLSA and the New York Labor Law, are commonly brought as class and collective matters. These are matters that are brought on behalf of not just one or two employees, but on behalf of a group of employees. As a result of the complexity and scope of these claims, these actions result in significant fees. These matters require additional motion work to create the class or collective, which ultimately ends up with additional fees. It is important to recognize that even where an applicable contract or statute provides for fee shifting will only occur if you are a prevailing party. This means that you were successful in the claims that you brought against a defendant, or where the applicable contract provides for it, you were successful in defending the claims asserted against you, i.e., you prevailed on your portion of the litigation. Likewise, where a party successfully defends an action brought under the statutes that provide for fee shifting, the right of a plaintiff to recover their attorney's fees is extinguished. In order to recover attorney's fees through a fee shifting provision in a contract or in a statute, there must be some matter that you prevail on. It is also important to note that a settlement in one of these matters described above does not provide for the shifting of fees. Attorney's fees are only going to be covered within a settlement if it has been agreed upon by the parties in the settlement. Additionally, this becomes complicated. This fee shifting structure becomes complicated where a plaintiff is successful on some but not all of their claims. In these circumstances, the court will review the submissions from counsel seeking their attorney's fees and to determine what fees are appropriate. Where the work on the unsuccessful claims are unrelated to the work completed on the successful claims, the court will reduce the attorney's fees sought by the time spent on the unsuccessful claims. However, where there is a common core of facts or related legal theories, the successful claims and unsuccessful claims can be deemed to be intertwined. That means that the facts that are at play that will determine that litigation are generally the same, or there's very little variation from those, i.e. a common core of facts. And similarly, the related legal theories is where your theory upon the case are very similar. Where the successful and unsuccessful claims are intertwined, attorney's fees may be awarded by the court on the unsuccessful claims as well as for the successful claims. The situation recently played out last fall in a case that made it to the first appellate level of the federal system, where we are in New York, the Second Circuit. This matter is Hollick versus Cellular Sales versus New York LLC. In this matter, the court awarded the plaintiffs fees on the majority of their unsuccessful claims because they determined them to be intertwined with their successful claims. These claims largely required the same proof to establish, primarily the documentation and records for the employee's employment with Cellular Sales of New York. Additionally, the court determined that the litigation for all of these claims, both successful and unsuccessful claims, arose from a similar legal theory, that their damages arose out of Cellular's misclassification of the employees as independent contractors instead of employees. Ultimately, the court awarded plaintiffs $576,870.30 in attorney's fees. In affirming this award, the Second Circuit also held that there is no mandatory bright line reduction that must occur where a plaintiff fails to certify a class or collective. In this matter, plaintiffs made an attempt to establish that there is a class or collective that applied to a group larger than just the small number of plaintiffs that brought the action and wanted to increase the scope of the litigation. They failed upon their motion, and the Second Circuit held that because they failed, there is no set amount that must be reduced from the sought attorney's fees. Accordingly, given the law and what we learned from Hollick, it's clients who are involved in litigation and negotiating contracts with fee-shifting provisions should be aware that it is possible for a party to prevail only in part, but still recover the entirety of their attorney's fees. As we mentioned, where the unsuccessful claims are intertwined with the successful claims, there can be an award of attorney's fees for those unsuccessful claims. That covers my portion. And for anyone who has any questions related to shifting of attorney's fees or anything more specific, please feel free to contact me or any of Bond's other litigation attorneys.
Well, thank you so much, Eric. That was really informative and just underscores how important it is to make sure those contracts are written in a way that stands up to these kinds of dynamics. And so let us help you with that if we can. And Eric, thank you for bringing light to those issues. Let me shift to our final speaker of the afternoon, who's going to be Jackson Soames, who's with us from Rochester. Evidently, Jackson knows a little bit about 80-degree weather, having attended University of San Diego before making his way east to Syracuse, where he attended law school, and again is now based in Rochester for Bond. And there's an interesting piece of legislation that we thought was worth all of your attention because it does have a variety of implications. The governor issued a veto recently about it, and Jackson's here to tell us why that happened and what ultimately didn't change as a consequence of that. So Jackson, the floor is yours. Thank you very much, and looking forward to hearing what you have to tell us.
Thank you, Gabe. Very happy to be here. So as Gabe alluded, I'll be talking about Governor Hochul's veto of the Grieving Families Act. I'll be talking about what was in the bill, the reasons why the governor vetoed the bill, and then sort of what the future looks like for the wrongful death statute in New York. So with that, Kathy, can we go to the next slide? So first of all, a wrongful death claim is a statutory claim. And in order to bring a wrongful death claim, it's usually a family member of a person who has died bringing a claim against the person who caused the decedent's death. Now, under New York's current wrongful death statute, those damages that can be recovered are primarily limited only to the pecuniary losses of the decedent. So for example, that includes like the value of services that the decedent may have provided or the direct financial support that the decedent provided. And the Grieving Families Act proposed 3 primary changes to this wrongful death statute. And the first one is the type of damages that can be recovered. So first of all, it would have broadly widened the scope of damages that can be recovered to include not just pecuniary damages, but also emotional and non-economic damages. That'll include claims for damages such as grief, sympathy, loss of companionship, or loss of consortium. And secondly, the Grieving Families Act would have extended the statute of limitations on these claims from a period of 2 years, which currently exists, and growing that statute of limitations period to 3 years and 6 months, so 3.5 years to bring a claim. And third, the Grieving Families Act would expand the class of persons who can recover on a wrongful death claim. Right now, the law limits the type of people who can bring a wrongful death claim only to distributees of a decedent's estate. And the Grieving Families Act would have broadened that class of persons to close family members. Now, interestingly, the bill rather, it didn't give a definition for close family members, and specifically it left it up to the fact finder, so the jury or the judge, to make a determination of who qualifies as a close family member. We can go to the next slide. Now, there are two primary reasons why Governor Hochul vetoed the bill, and she stated those reasons in an op-ed that was released on the same day that the veto was handed down. And her first concern related to the Grieving Families Act was its economic impact that it could potentially have. So she was worried primarily that this bill, because it expands the class of persons who can bring a wrongful death claim, because it expands the statute of limitations, because it expands the damages, potential economic impacts of all that would be higher insurance premiums, because it expands the potential risk and the potential damages that can be brought under a wrongful death claim. And where she was particularly concerned was in the healthcare industry. She stated very clearly that she was concerned that the wrongful death statute under the Grieving Families Act would drive up already high health insurance premiums. And she was concerned about what impact that would have on the health insurance and the healthcare market as it's recovering from the COVID-19 pandemic. And we can go to the next slide. And also in her op-ed, Governor Hochul, she listed some specific recommendations for what a future bill might look like, what a bill that she would sign would include. And she stated very clearly that she would sign a bill if it had specific exemptions for medical malpractice claims, so that these types of expanded emotional damages wouldn't impact a medical malpractice claim. Once again, highlighting her concern for the healthcare industry. And she also suggested limiting these types of claims specifically to parents who suffered the loss of a child, and only limiting the amount of claims that that parents could bring for emotional and non-economic damages to the loss of the child. And if we move on to the next slide. Now, even though Governor Hochul, she vetoed this act, it's highly anticipated that a new version of the Grieving Families Act will, at the very least, be introduced in 2023. And the reasons for that are, first of all, this bill was a long time coming. The first version of the wrongful death statute in New York State was passed in 1847, and it has been substantively largely unchanged since that time. So, an update to this statute has been in the works for a long time. And secondly, there's been some broad bipartisan support for this bill. I put the votes in the Senate that this bill had, and as you can see, it was widely supported. It was almost a little bit of a surprise that Governor Hochul didn't sign the bill. So in 2023, we can expect probably a new version, maybe a version that more closely aligns to Governor Hochul's vision for the update to the wrongful death statute.
Well, Jackson, thank you. That's really useful information, and it speaks to the nature of what are complicated decisions in the legislative process. And the governor, as I think we've talked about here on the program, didn't issue vetoes until really beginning in November following the electoral cycle. And this was one, as you point out, that wasn't entirely expected by those who were prognosticating, but that you laid out the roadmap in terms of what the governor may be looking for is helpful. There are lots of interests that I'm confident are already aligning around, what that new language would look like. And Jackson, hoping that you'll keep all of us posted if there are changes we should be aware of. And with that, I wanted to just give all of you a chance to pose any questions that you have. I don't see any coming through the chat, but what you should always feel free to do, please, is to reach out to any of the individuals who've presented here or to me. We can answer anything offline that you may have. The bond attorneys with whom you work are also your resources. I look forward to being back with you when we flip the calendar unbelievably into March. Next week, you'll be with Adam. And in the meanwhile, hoping that you all stay safe and well out there. And thank you for tuning in. We appreciate your loyalty to the program.